Good evening, everybody, and welcome. Welcome to meet the arbitrators. There are more in the audience as well. It might have been thought that arbitrators are inconspicuous, distant, hiding behind the curtains, rarely seen other than at hearings. But that might have been in the past. Just like the royals. Here we have, as you can see, more than 3 friendly LMAA arbitrators, and Bruce Harris in the front, who is really the leading arbitrator of the LMAA. And he's friendly, yes. He's friendly. I thought I make this an interactive play. It's more fun learning together. So there are 2 producers of this play, the LSLC and the LMAA. Our chosen cast, apart from my fellow arbitrators, is the young maritime professionals. I refer to them as the cast because they also will perform during the Q&A sessions. Now, of course, I can see in the audience some attendees who are over the age limit of the YMP, or do my eyes mislead me? And of course, a play needs an audience. So your role will be to show your appreciation to those who perform. I am the director of the play, and Francesca Cappa, the chairman of the YMP, she's the stage manager who is going to filter the questions during the Q&A. The order of performances is this. Each actor, arbitrator, will set out the issues of their topic in 3 to 5 minutes, no more. There will be questions after each issue for 10 minutes, and there will be more discussion at the end. I hope we'll have time. The performances are adapted to meet the concerns of the YMP. There are some difficult areas in our practice of arbitration, and we thought that this is the perfect forum for the debate. There will be 1 act of 2 hours, or 1.5, 2 hours if we have questions. No interval. My fellow arbitrators are well-known actors to you. There is no need of introduction. You can read the bios, you've already received them, but you can Google us as well. So let's begin. Curtains up. David, the president of LMAA, over to you.
Thank you very much. The London Maritime Arbitrators Association, a small association full of small, friendly people. Right, 3 to 5 minutes on the role of the LMAA and the application of the LMAA terms without hesitation, deviation, or repetition. Very good evening, everybody, and thank you for coming out. We're delighted to see so many of you here. The role of the LMAA. The LMAA is a membership association. It's an association of practicing arbitrators. It's not an institution. We don't administer arbitration references, and except in very limited circumstances, we don't appoint arbitrators. You could probably say that although we have a number of objects and functions, the primary ones are to publish and keep up to date the LMAA terms and procedures, promote the use of those terms and procedures and promote London maritime arbitration, and give guidance to our members on best practice. When do the terms apply? Well, the most obvious situation is where an arbitration clause expressly refers to them, and that's by far the most common situation. You'll very often find a clause in a maritime contract that says the contract's governed by English law, the arbitration will take place in London on LMAA terms, usually those current at the time when the arbitration is commenced. But what happens if there is no such express reference to the terms in the clause? Now, this can be quite significant. I've had a couple of cases recently where this has led to some skirmishing. I had one where I was the chair, and of the two party-appointed arbitrators, one had accepted their appointment by reference to LMAA terms, and the other had not. And the respondent objected to the application of the terms, and we took the view that in that situation, the terms didn't apply. What we managed to do eventually was encourage the parties to agree that at least the second schedule to the LMAA terms, the procedure, would apply. The other case I've had recently is where the arbitration clause was silent on the terms. I, as I customarily do, accepted on LMAA terms, and one of the parties took the position that that was an invalid appointment and that I hadn't been properly appointed. Clearly wrong, but it was an argument that was advanced. So what happens? Well, the practice in most cases is, particularly for full members of the association, we accept our appointments expressly by reference to LMAA terms. And where we do that, it's clear that those terms will govern our contractual relationship with our appointing party. So things like interim billing and booking fees and so on will be governed by the first schedule to the terms. It doesn't necessarily follow, however, that the terms will govern the procedure of the arbitration. Rather than spend a lot of time discussing this now, what I'd like to do is commend to you Clare's book on London maritime arbitration, and you'll find in the notes a reference to the relevant passage, which deals with paragraph 5 of the LMAA terms. And the terms set out an attempt to ensure that the parties are taken to have agreed the application of the terms in certain circumstances. But very briefly, I think the important takeaway here is that there has to be a degree of consensus. And so, for example, it's unlikely, in the absence of an express reference in the arbitration agreement, it's unlikely that the terms will apply where there's a default appointment of a sole arbitrator, and it's unlikely that they'll apply where one party has objected to them and has not acquiesced by continuing to take part in the arbitration on the basis that they know the terms are intended to apply. Just a couple of other small points. One is that the parties are free to agree to the application of the terms after the commencement of the reference. It doesn't have to be in the original arbitration agreement, although it commonly is. Or they can agree, as in the case that I described, to application of part of the terms, for example, the procedure in the second schedule. So far as the small claims procedure and the intermediate claims procedure are concerned, there's quite a common misconception among users that if there's a reference to LMAA terms, that automatically brings in the small claims and intermediate claims procedures. It doesn't. Those apply only where there's agreement between the parties. I suppose if, depending on the precise wording of the arbitration agreement, if it referred not just to the terms, but to the terms and procedures, then that might be enough to incorporate everything. But again, there's nothing to stop the parties agreeing to the application of either of those procedures once the dispute has arisen. That's it. Questions?
Thank you, David. Now, any questions from the floor, or Francesca will ask those who are remotely? Have I muted?
Richard.
Good evening.
Okay.
Blimey. Sometimes you see reference to a commercial man, or I guess commercial woman, and I wonder whether you could comment on what's meant by that. Is a retired judge that only does arbitration these days a commercial man or commercial woman? Keen to know.
It's a very interesting question, Richard, and one on which I would hesitate to give a final answer. First of all, despite the use of the term commercial man, as you say, it's gender neutral and it's clearly understood that it refers to women as well as men. It certainly covers full-time maritime arbitrators, such as the full members of the LMAA. Whether it would cover a retired judge, I'll defer to others on that. I have some doubt about that. What's your view, Richard? we're gonna pass this one round.
Well, I think if the retired judge has become a full LMAA member, they suddenly become a commercial man.
But the qualification, Claire's right, but of course the qualification of that is we don't currently have any retired judges who are full LMAA members.
I think Bruce has a different view. No? We don't have any more retired judges. We used to. Yeah, okay.
If I could just add something. Wow. Once I get the distance right on this, one particularly esteemed ex-High Court judge who now sits as an arbitrator, is often the third one appointed, did, when this arose in one of my cases, consider himself to be a commercial man.
He did. Oh, that's interesting. Okay. David.
Press it.
David Boxall, I'm a consultant. I actually consider myself to be a commercial man, but I'm not a lawyer.
That's even better. Definitely.
Yeah, so, but does not being a lawyer preclude me then from becoming an arbitrator?
Not in the least. Absolutely not. Arbitrators, maritime arbitrators, come from a huge range of backgrounds, and a number of our full members are not lawyers. In fact, our most recent full member, Captain Keith Hart, is a very eminent master mariner who has experience both on cargo ships and in the offshore energy
Sorry,
sector.
we'll cover that at the last topic.
We're going to cover that as
Cover
another
that
topic. I
as
mustn't
a
anticipate
the last topic,
But,
yes.
but the short answer, David, is that I mean, my personal view, subject to the views of others, is that when people put commercial man in their arbitration clause, they're trying to avoid finding themselves with a tribunal of pure lawyers. Otherwise, why would they use the term commercial? I think what makes us commercial as full-time arbitrators is that we're dealing with commercial arbitration on a daily basis, not the fact that we are qualified lawyers. That makes sense? Maybe, maybe not.
I'm going to be a bit difficult because I can't cite chapter and verse, but I think I've recently read a report of an insurance case where the clause required somebody experienced in insurance. And the court held that a QC who'd spent a lot of his life dealing with insurance cases was not qualified under that clause. There might be a parallel there.
Yeah.
Okay, other questions from the floor? No, other questions? No, okay, can I ask you one, David?
Yes, of course.
Just a quick one, because there may be confusion in the market. The first, under 5A, where it says whenever the dispute is referred to a sole arbitrator who is a full member of the association, I take it that this is an implied word there, an agreed sole arbitrator, who is a full member.
Well, I think this rather reflects what I said earlier.
Yeah,
I
yeah.
think, Aleka,
But this leads me to another question.
Oh, sorry,
But
okay.
the main question is really, with a difficult clause, you find many years, and they haven't corrected that clause in charter parties, arbitration in London, English law to apply, you find that clause still. And the problem is, some people think if you refer to 5A, the problem is solved. Is it solved?
Well, the purpose of 5A is to deem an agreement effectively. I mean, there obviously has to be a degree of consensus terms. But what 5A is trying to do, and the extent to which it's successful is open to discussion, but what it's trying to do is deem an agreement that the terms will apply where there's a sole arbitrator who's a full member of the association.
Okay.
Now, as I mentioned earlier, I don't think that would work if it were a default appointment of sole arbitrator, but I don't think that's what you've got in mind.
No, the point is the clause. The troublesome clause, arbitration in London requires agreement of the parties to a sole arbitrator before you appoint. If you do not agree and the other party is uncooperative, you have to go to court to appoint an arbitrator. So this, some people think that 5A helps them to avoid going to court. But if you can't get the cooperation of the other party, you can't rely on this 5A, in my view, and I think you agree with that.
I can see that.
You have to get the consent
I
of
can
the
see
other
that point of
party.
view. Claire, do you have a different view on that?
They are difficult, these points.
They're difficult.
And
They are,
so if
yeah.
you agree LMA arbitration, does that bypass the default? Oh no, LMA arbitration without saying sole gets you 3 arbitrators and you're okay. If you say sole arbitrator,
No, you
then-
don't say anything. You say arbitration in London, English law, nothing else.
LMAA, that
No
will get you
LMAA
that
and
will get
nothing
you a
else.
3-person tribunal.
No, it doesn't get you.
Is
Arbitration
that
in London
defaulting? Yes.
is a sole arbitrator if it is agreed.
What you're contemplating, I think, Aleka, is no reference to the LMAA
No,
terms,
but no reference. at all.
no specification of the number of arbitrators.
Exactly, yeah.
And so under the Arbitration Act, that's deemed to be a reference to a sole.
So that's
The
it.
sole
Yes.
arbitrator, I have,
Um,
yeah.
And I can see your concern. If you have an uncooperative respondent
It's
who
not my
doesn't want to,
concern, it's the party's concern.
the party's concern is that if they have an uncooperative respondent who doesn't want to agree on a sole
Yeah,
arbitration, you have to go to court. Query whether there is sufficient consensus, even for paragraph 5 to solve
Exactly,
the
yeah.
problem. That's your,
Yeah.
and it's a difficult
I
question.
tend to agree 5A will not get you home.
Yeah, it does. Okay, now move to the second issue. Claire, please.
Yes, I'm going to be talking about interim relief and arbitrators' powers. This is a complex area. I've got 4 minutes to give you a sketch. So I'll start with the basic starting point that arbitrators can generally make any final order that a court can. So you can grant orders to pay money, final injunctions, declaratory relief, and specific performance. And they have those wide powers, but the difficult area is where a party wants an urgent injunction, something like a freezing order or an anti-suit injunction, pending the final decision on the merits. And the power to give that sort of provisional interim relief is only available if the parties agree, and that's section 39 of the Arbitration Act. And some institutions have rules about interim relief, and they have emergency arbitrator procedures, which amount to an agreement that the tribunal will have powers to grant those sort of urgent injunctions on an interim basis. The LMA doesn't have those provisions. A view was taken, probably correctly, that a court, typically the commercial court in London, is better placed to grant urgent freezing orders or anti-suit injunctions. There are difficulties on due process in terms of an arbitrator making a decision ex parte, enforceability of emergency arbitrators' decisions. And also these emergency procedures are expensive. So the advantage on costs is borderline. So the position in LMA, where you've agreed LMA arbitration, the tribunal doesn't have power to grant an interim injunction unless the parties agree. So if the parties go along and ask the tribunal, could you could you decide whether an interim anti-suit injunction should be granted, then the tribunal will have power. But in real life, these urgent injunctions are typically very contested. A freezing order is generally not done by consent, and typically you will have to go to court, usually under section 44, and establish urgency as to why you need to go to court and why the tribunal is unable to act. And there's clear authority on the LMAA context there. So if it's an LMAA case, the court will understand why you're coming to court. If it's an LCIA one, it's more tricky. And that's a good reason why for not having the emergency arbitrator procedure is that it's pretty clear that the arbitrators can't do interim relief unless there's agreement and the court can, whereas in the LCIA situation, it's a bit more hazy. So interim relief not available from the tribunal without agreement, but if you want final relief, then an LMAA tribunal has power to give that relief, and you make an application, you exchange statements of case, both sides are heard, and the tribunal will make an award. All that's on interim relief. I also want to add that tribunals obviously have very wide powers over evidence and procedure, things like orders for production of documents, or specific powers like security for the costs of the legal costs of the arbitration, and preservation of evidence. So those are powers that tribunals do have, and that they can give orders that are not necessarily final orders, but they're different from the interim relief that you might normally consider of things like freezing orders. So that's the interim relief. I don't know whether you want me to move straight away onto expedited procedures or right. Well, it's quite similar. When I'm talking about expedited procedures, I'm not talking about, I'm just talking about getting things done quicker. I'm talking about timetables that are speedy. I'm not talking about specific procedures that you may have, say, under the ICC rules, have a specific expedited procedure. In LMAA arbitration, there are lots of different tools for trying to get things done quickly. And in terms of getting things done quickly, urgent applications are obviously something you want to get done quickly, and that's something I've covered already in terms of interim relief, that a lot of those urgent applications may need to go to court. If it's an urgent application that's within the tribunal's power, obviously then it's for the LMAA tribunal to be considering. And tribunals can provide expedited procedures for things like document disclosure, getting that done quickly rather than waiting until the LMAA questionnaire. Sara will talk about that. You can get things done quickly. The bottom line, if parties want a quick turnaround, is that cooperation will help. The tribunal will be led by the parties' agreement. So if the parties, awards can be produced within 48 hours if the parties will agree a timetable. What's more difficult is where the parties aren't going hand in hand asking for a quick timetable. And in that situation, one side is wanting to get things done very quickly, and the other side is saying, well, we need more time, we should be going under the LMAA timetable for statements of case and the like. And in that situation, if you want the quicker timetable, you have to establish that fairness requires a quicker timetable. You have to show that the matter is urgent. You probably need to produce evidence of prejudice, that if this takes a year to decide, it won't be worth deciding. And you need to also show the tribunal that your timetable will be fair. So again, the tribunal needs to give both sides a reasonable opportunity to put their case, but that doesn't mean the tribunal's tied to the LMAA schedule for statements of case or the like. In terms of getting things done quickly, something that's already within the LMAA terms is that you can ask the tribunal to proceed to an award after statements of case have been exchanged, and that's within the existing terms. And that's a fairly easy way to get a prompt final determination, but the parties need to agree on that at the stage when they would otherwise go to questionnaires. And it does happen quite frequently, and it is a way of getting things decided quite quickly. Another tool is partial awards on preliminary issues. So if one side decides they want to carve off part of the dispute and try and get it decided at an early stage, then they can make an application. It's even better if both sides agree on that. And the tribunal will decide whether it's appropriate. It's most appropriate for things that don't need an investigation of evidence, but the tribunal's got wide powers as to when it's appropriate to decide something at an early stage and leave over other matters. Another point I raise is that tribunals, effectively preliminary issue determinations, are also often called summary determinations, especially if you're looking at a question of law. And I think clearer powers for summary determination of issues are quite likely to be confirmed in the new Arbitration Act if the bill goes through. The bill's going through Parliament. If it goes through, that act does contain provisions confirming summary powers to make awards. And I think that could be a game changer in helping to avoid delay and unnecessary costs, because it means that parties can say, look, there's no real prospect of success in them defending this. Why are we doing disclosure? Why are we having witness statements when you can proceed on the material you've got? I think in LMAA disputes, there is already a fair amount of pragmatism. There are a lot of disputes being decided on paper already. So for medium-sized disputes under LMAA terms, it may not change things so much, but I think it will change the climate. I think there will be more applications. There'll probably be a transitional period where things settle down, but eventually I think it probably will help to avoid delay.
Thank you, Claire, for a succinct exposition of a very difficult topic. And because of the difficult area, I suppose you will have questions. Any questions from the floor? Francesca, any questions?
We did have one, but I think Claire has already answered the question, because I'm going to ask it, and maybe if you want to add anything. But where both the court and the tribunal have power to issue interim relief, anti-suit injunction, which forum is more appropriate if the arbitration is afoot?
If it's final relief, then you've got to go to the tribunal, and it's only the tribunal
that can do
it. And final anti-suit injunctions are quite common. Often you don't really need them to be on an interim basis. You can just say, well, you've breached the arbitration agreement, stop, and that's a final order. If you do want it on an interim basis and the parties aren't agreeing, then you'll need to go to court. The situation you're talking about most commonly arises in LCIA cases where the rules allow you to get interim relief. And so you're in a slight twilight zone as to whether you can go to court. And that's probably a problem area that I think is experienced less in LMAA cases. Although I have had situations where applications are being made and there is a sort of court proceedings going alongside, but I think it's less problematic where it's an LMAA case.
Thank you.
Yes.
Thank you.
Yeah.
Okay, thank you for that. Just you mentioned about preliminary issues. We just actually in practice, we're finding it's getting very difficult actually to get these approved by the tribunals. So in some instances where there are like complex cases, like 6-7 legal issues, and the parties submit actually for a preliminary determination 2 of these issues, the tribunal often say actually this will not make the claim go away, but actually the bulk of the quantum of the claim is actually in these 2 issues. So I just wondered in practice, what is the real threshold the tribunal is looking for?
Well, speaking from the tribunal's point of view, there's a slight danger that if you decide part of it and factual issues and you produce an award, and then the second part is stage 2, you'll undoubtedly find that there'll be a dispute about how much have you decided on round 1 and what did it mean. And it can cause costs to escalate, so that actually often it's not so efficient to have stage 1 and stage 2. And even with quantum and liability, often you'll find that quantum depends on the liability issues will be determined by the quantum issues. So again, it may not be quite as efficient as some parties think to split the issues. Tribunals are open to preliminary issues. If you want them, you need to think carefully about how they're drafted. You want to get them agreed, and you want to hive off the factual issues as much as possible. That's how you get tribunals doing preliminary issues, that in my experience.
Yeah, I agree with Claire. I think that's exactly right. We're certainly receptive to the idea of preliminary issues. If it's a knockout point, such as a time bar point or something, then no doubt. But one of the things that troubles me is that sometimes, depending on the issues and the amount at stake, sometimes it's in the party's interest that we just crack on and resolve all of the issues at one time. Because if you hive off a preliminary issue, you may find that it takes time to resolve. Then there might be an appeal against the award on the preliminary issue, and you can end up spending more time and cost when you come back to the balance of the issues than if you'd just pressed on from the beginning.
I think that was a no. So hi, I'm Julia here from Nautical Law. I just wondered if you could expand a bit on the difficulties re-enforceability of emergency arbitrators orders. The reason I ask about that is, and this is just without having done any sort of background reading since 2020. I think since Brexit, my impression was that in some places it may be easier to enforce an arbitration award than to go through the process of enforcing a court order or award, because in the absence of Brussels 1, enforcing a court award is a court order is difficult, whereas many states have signed up to international conventions that provide for automatic enforcement of arbitration awards. So I was just very interested to hear more about why enforceability of why emergency arbitrators orders have sort of enforceability difficulties.
Well, there's quite a big debate on whether emergency arbitrator orders are within the New York Convention, because they're not final, they're interim, and they're provisional in a sense. And there's a debate, an academic debate and a debate in practice as to whether an interim order is within the scope of the New York Convention. In terms of due process, there's a big issue. I'm doing an emergency arbitration at the moment, and it's being done ex parte, and I have great doubts as to how enforceable it will be. It may be useful or may not, and the same goes for an ex parte anti-suit injunction. So I'm not saying that they're inherently problematic for that, but there is an enforceability issue both for the court order and the arbitrator's order. So those are specific problems, and also you've got to get the tribunal constituted. And I mean, LMA constituting a tribunal can be quite quick, but if one side's not cooperating, it's not always so quick. So to get it done at an urgent level in terms of being able to get an order by the end of the week is not a given. So those are the sort of problems that I think have been reasons why the scheme hasn't been, the LMA hasn't adopted that procedure. So it's interesting. If Brexit has changed the goalposts, it's probably worth considering, but that's my understanding of the issues.
Thank you. Bill Amos, under 60, from Hong Kong. Question for Claire on the emergency arbitrator procedures. This isn't a plug for Hong Kong, but under the HKIAC, emergency arbitrator applications are always dealt with inter partes. You can't do an ex parte one. And that probably rules out a lot of freezing injunctions, Moreva types of applications. I'm just wondering, you mentioned that you're doing an ex parte emergency arbitrator case. And I'm wondering under which rules you're doing it.
Well, that's something I probably am not going to be discussing, but you can probably check the rules around for yourself if you want to look, but
I have to do a Google search.
yes, go ahead.
Thank you.
From Hong Kong, welcome, David Amos.
Oh,
This club.
Bill.
Bill, sorry. Yeah.
Thank you, Aleka.
Can I add to the question of enforcement? What's this lady who asked the question? Just to make sure, actually, whenever anybody wants emergency arbitrators or emergency application to get an interim relief, you must check where you're going to enforce whatever you're going to enforce, which jurisdiction you're going to enforce it.
And I think the emergency arbitrator orders are very useful if you are trying to enforce. There are some jurisdictions where they are quite useful, and I think that's why
US.
Singapore and
United
Hong Kong
States.
have brought them in. Well, I'm thinking of somewhere like Indonesia or
Yeah.
somewhere like that, and I know that they are seen to be useful in that context, whereas a commercial court order might be less useful. I haven't heard the Brexit context, but I have heard that they're useful when you're trying to get something done in Indonesia and you're faced with having to go to an Indonesian court, and actually it's more attractive to go to a London or Singapore or Hong Kong tribunal to get your order than going to the court in Indonesia. You don't always have the privilege of being able to sort of get your order in the commercial court. So that is an advantage. And I mean, there's a balance, and clearly they have been quite successful, but there are drawbacks.
Now, we've done our 10 minutes. We've done 10 minutes on this topic, but if there are more questions, because it's the most difficult and juicy, before we go to disclosure, but we can have more discussion at the end. Let's move to disclosure with Sara. Sara, please.
Evening. I hope everyone can hear me. Yes. Disclosure. Well, it's about information, and arbitration is about dispute resolution. So information is always key in relation to dispute. And I'm always slightly surprised as to why quite often one sees answers in questionnaires that standard disclosure is yet to take place, and an assumption that LMA disclosure follows, or any arbitral procedure follows, court-style disclosure. And it doesn't, and the terms don't require that. So I'd just like to run through some of those terms to point out the rules. Paragraph 1C, submissions with supporting documents, i.e. relevant to the issues between the parties. And the terms actually spell out an explanation sufficient to identify the issues in the case, but not burden the tribunal with the superfluous. For example, copy invoices at the beginning of a reference. However, I would also say, please use common sense. If the dispute is about non-payment of invoices, for example, port expenses and between owners and charterers costs, or additional war risk premiums, no claims bonus, etc., then those invoices are important, and I would say they're relevant to the issues in dispute and should be disclosed. Then you also have, for example, disputes about access to logs, where there's been a breakdown of the vessel, or perhaps even not quite sure what has happened to the vessel during a journey, and speed and consumption disputes. And all these are relevant. And I know that there's some users, as a matter of tactic, like to hold their powder dry. And in court style or in court proceedings, it's not usual to supply documents with submissions. But this is LMAA, it's alternative dispute resolution. And just to be aware that under paragraph 2, there are actually possible cost penalties for failure to disclose relevant documentation at the relevant stage. And it does come up and it can be applied. As regards early disclosure, and by early, I mean prior to submissions, under paragraph 8, the terms provide that you must seek the agreement of the other party. And if you can't get their agreement, then you have to make a written application to the tribunal explaining the parties' positions. Now, what we quite often see in practice is basically a long list of documents, perhaps 15 types of documents, not a specific document. And it's starting to look like a fishing expedition, and you haven't got submissions. And the parties may know what the dispute is about, but the tribunal doesn't. The parties may know that it's a deduction for a speed and consumption dispute. It may be about cause of damage to either vessel or cargo, but we're not in receipt of that information. So you need to explain to us why we should not follow the usual procedure in the second schedule. What is the reason? What is it going to achieve? Will it resolve issues in dispute? I think most people would say that, otherwise we wouldn't be applying for them. But key questions are procedural efficiency, saving on time and costs. And, you know, this is back to the point about information is key to resolving a dispute. But you do need to explain to the tribunal why access to those documents that you're asking for will achieve that. And frankly, a lot of the applications we see resemble fishing expeditions. Please also remember paragraph 9, that the parties are entitled at any stage, and I underline any stage, to ask each other for documentation they consider relevant and not previously disclosed. And I suppose that's bringing in the different strands under paragraph 1 and paragraph 8. So basically then, I hope everyone here will then be seeing that we're actually talking about a specific disclosure. We're not talking about court-style disclosure. Why does everyone in their questionnaires say standard disclosure yet to take place? And, you know, thinking strategically about the dispute that you're handling, as Claire said, you know, a lot of disputes or awards now go by documents alone. So if you haven't disclosed them with the submissions, when are they going to come up? Then you may need disclosure. Then you may need another round of submissions after disclosure. But in some more straightforward, obviously more straightforward, tend to be more moderate sums. But if you've got the disclosure with the submissions, and it's all on, if you like, on the table in front of you, in front of the tribunal, then it's very easy to go to an award on documents only without having further rounds. So again, just think about procedural efficiency here, which is key. That's what we're all after, time and costs. And personally, I don't think there's much to be gained from sitting on documents, as some people do. Talking about specific disclosure, a question that often comes up is red fern schedules. I don't see what the problem with them is. I think they're quite useful. If you think about it, from our point of view, as arbitrators, we quite often get a chain of correspondence, and it becomes a very long stream of correspondence between the parties that will then be before the tribunal, where each party will be given an opportunity to comment. And this just gets longer and longer, basically. And if you have a schedule, and it doesn't have to be a red fern schedule, which is a specific, you know, format, but it can be a Word document that's just with columns, you know, this is the issue and dispute type of documents, what party A says, party B says, what are we being asked to decide? And if we look at that in front of us, whether it's Word or Excel, then it's very easy for the tribunal to have a discussion about the different points. And then also in that final column, write, you know, what the decision is. So it's a matter of presentation. And certainly, and this is a personal view, I find that kind of presentation, whether you call it a red fern schedule or something more informal, I find that very useful. Finished? Is that finished? Can I have 2 minutes more?
What, 2
Literally
minutes?
2. Well, okay.
Claire took 5 minutes. She had huge.
Everyone else
Okay,
took lots of
go
time,
ahead.
Aleka.
Go ahead.
I've been waiting a long time for this. Okay. I also wanted to mention also about dispute resolution, consider different routes. There are powers under Section 38 on inspection, sampling, etc. If you have a bunker dispute and need access to samples, it may be an advantage to basically have them tested at the commencement of the arbitration before you've even exchanged submissions. And I've made decisions, I've been asked to make decisions along those lines. The same with vessel access to a vessel, where a bareboat charterer won't let an owner have access to the vessel, which is quite interesting. But anyway, there are other, it's not, you know, everyone gets this idea that sort of submissions will be done first, then it's questionnaires, and then it's disclosure. It's not. Think about how to resolve the dispute. What do I actually need? I need information, I need access to the vessel, or I need access to the bunker samples. And just one final comment. Thank you. So I would just make one final comment, that even when you have standard disclosure, because I know a lot of people like that and will carry on doing it, you may still get that discussion about the production of, you know, has it been complied with? Have the right documents been disclosed, etc. You still get that discussion, whether you have standard disclosure, red fern schedules, however you do it.
Thank you. Well done. Now, questions. We have one question from Zoom. Okay. No, here. Okay.
Yeah, hi. I'm Harry from Greece, training with Jackson Barton here in London. Thank you for this presentation. My question on disclosure is, when a party withholds a document recognizing a fishing expedition, this will probably give rise to an adverse inference. So my question is, how impactful is an adverse inference in decision-making for tribunals? Thank you.
Well, yeah, it's something that a lot of people get very excited about, adverse inference. In relation to a discussion about a document, whether it's being withheld or not, or whether it's truly not there, or the person or the party concerned doesn't actually have control or access to it. And quite often there is an explanation. We don't necessarily know the reasons, particularly at that stage of the proceedings and before a hearing or before final submissions. So it's quite difficult to draw an adverse inference in the same way as the reference to adverse cost consequences. But what I think a lot of people do, and certainly what I would do, is refer to a possible adverse inference or adverse cost consequences, so that you're pointing it out. So it's there as a sort of, you know, it's on the table, it's been mentioned, but it's a bit early, perhaps, in the proceedings, unless you're being asked to make a decision. But it's probably a bit early to say that's definitely going to cause an adverse inference, unless it really, you know, it all depends, doesn't it? I can't say for any situation, but generally in those kind of situations where you have that kind of debate, it can be a bit premature to say that's definitely an adverse inference, or it could be blindingly obvious that there will be an adverse inference, and no.
Hello, my name is Juan Abud. I'm from Venezuela. I'm a legal consultant at Preston Trimble. I would like to ask about, while preparing a disclosure, what is approach when I wish to identify which documents are protected by legal privilege, especially if we're talking about communications between, let's say, clients and foreign lawyers. That would be all.
Yeah, that's a bit of a loaded question. There isn't an easy answer. There are various rules about what is privileged or not in terms of client communication with a lawyer. And I used to work in-house, and I was always lived in fear of, you know, what was basically privileged or not. And there's been a lot of cases in England recently that I would say are perhaps limiting legal privilege. One has to be very careful, and how legal privilege can also be accidentally waived in proceedings by being referred to. And I think that's also a concern that foreign lawyers have when they're arbitrating here.
But advice from foreign lawyers is just as privileged as advice from any lawyer. So that the status doesn't affect the privilege.
Yeah.
That will, thank you.
Question?
Yes.
Yeah.
Thank you.
Hello, it's me again, Julia from Nautica. I just had a very simple one. Under what sort of circumstances would you consider granting an order for effectively pre-action disclosure or disclosure prior to service of submissions? I think you mentioned paragraph 8 of the second schedule of the terms. So is it similar to pre-action disclosure where it's available under the CPR, or are there other considerations or other situations where you'd grant disclosure prior to submissions?
Well, we're talking about arbitration rather than CPR, so CPR doesn't apply, though of course a lot of users look to them for guidelines. I would say it has to be relevant to the issue in dispute. When I say not a fishing expedition, one has to explain why it's believed that that document is relevant to the dispute, why it would resolve the dispute in a prompt fashion. And I've seen it in a situation where, for example, there might be a deduction made by a charterer, for example, and then in relation to costs incurred, but the owner hasn't seen, or there's a dispute about whether that deduction is justified. And you know, one can be quite specific. I think what I see is that most people aren't. So it's a bit difficult to say, and this is only a personal view, but it is quite difficult to say what one would do, because it's almost easier to say what one wouldn't do. The circumstances need to be explained in a way that it would resolve matters.
My experience is there are more and more applications for early disclosure, because the court is also expecting parties to produce documents at an earlier stage. I think there's much more greater willingness to order early disclosure before statements of case if they're focused requests. If it's, this is speed and performance and we need a log for these specific dates. But what I do sometimes see is they've gone to see an expert and they've got sort of every possible document to do with that ship. And that's too onerous and potentially a fishing expedition, and too expensive and not thought through. And so if you want pre-action disclosure, think it through and justify it and make sure it's not too onerous, and then you've got a fighting chance.
May I just add that they are strenuously resisted. In my experience, I had a couple, and the arbitrators have to be astute to see which is a fishing expedition and which is a real, which is, it means something for the claimant to make the statement of claim. But in the other one, I didn't grant it because it was a fishing expedition. The claimant should know how to start the claim. And if it is strenuously resisted and there is merit in the resistance, then you have to play by ear according to the circumstances.
Can I just make one more comment in relation to that? There are, we do see more applications on early disclosure, and there are different views among different arbitrators, but as Claire's explained, really it's about the focus. But I would also say this idea that you put in claim submissions without any documents or only the charter party, and sort of keep your powder dry and see what happens, what comes up with in defense. When it's a dispute, when you probably know, or the people preparing the submissions probably know what the background is, or at least can gauge whether it's 50 or 80% or 100% of it. They at least have an idea. And I personally find that quite helpful if someone is saying, well, this is what we think the dispute is about, and we're going to address that, and these are the issues, reserving the right after the defence to come back and readdress them. But the point is, if you're very sketchy in your claim submissions, and then the defence submissions and counterclaim become, if you like, the driving force, you're then into probably additional rounds of submissions, you know, rejoinders, etc. And in terms of efficiency and cost, it's prolonging the procedure. So again, you know, specific disclosure earlier, please, not necessarily before submissions, but earlier, will actually, in the whole, when you think about resolving the whole dispute, be more efficient.
Thank you.
Anybody else? We've done our 10 minutes. If you have more questions, we have more discussion at the end. Let's move to the next one. Gerard, LMAA Questionnaires.
So that forms the sort of the background, that's better, to where we're looking at the questionnaires. The LMAA questionnaire is sometimes regarded by some solicitors, and certainly I was a solicitor, and it may have crossed my mind as well, has been a bit of a pen to do. But actually, it's actually quite an important document, because if you sit down and look at it, you are thinking about what the case is really about. And often you find cases drift a bit and people don't really think what it's about. And this is your stock take. It's your opportunity to think, what do I need to get this case from A to the award, or whatever the conclusion will be. And it is worth, I suggest, taking your time to fill it out properly, because if you don't fill it out properly, you probably haven't thought very well about the case, and it probably will bite you later. So that's the purpose. It's an important document. Do you need it at all? Well, if you read the Schedule 2, then obviously it's one of the steps in your procedural timetable, as it were. But the LMAA rules also suggest that parties may want to think at an early stage whether a case should be determined on documents alone. If you're thinking that, maybe write to your opponent early, I think it's a documents only case, and don't just plod your way through the submissions, and then I get to the stage where I do the LMAA questionnaire, and then I think about what's going to happen next. If you want to make things a bit quicker, think and talk to your opponents. You may find they agree that it's a documents only case. And certainly as tribunals, when you're picking up submissions, sometimes you look and think this is really a documents only case. The sooner the parties think about it, you don't need to do that questionnaire, you can get there by agreement earlier. Talk to each other and think about it. So when do you need to do it? Well, strictly speaking, under the rules, it's 14 days after the close of submissions. I have to say, I find in practice, it doesn't always arrive after 14 days. And in fact, I'm quite surprised when it ends after 14 days. But I would suggest try and keep to it, because it allows you to move the arbitration along quickly. So as it says 14 days, try and keep to it, but people don't. And whether tribunals will want to enforce that 14-day rule, I don't know. Some people do, some people don't get so excited about it. Where do you find your questionnaire? Well, it's in Schedule 3, and it sets it out in very long detail. But it's worth sitting down, looking at it, and thinking about it. What does it cover? I'm racing through this quite quickly. The reason I say it's quite important, because there is an assumption amongst parties within arbitration that the tribunal read every single word they've written in submissions in great detail as soon as they arrive on their email. You'd be surprised to learn they don't always do that. To keep costs down, most arbitrators will have a quick skim through, just work out, is it a demurrage case? Is it an off-hire case? Is it an MOA dispute? What is it about? They don't necessarily sit down and think about every single issue, every single word you've written. And so the questionnaire allows the tribunal to open it up and see what the parties think the case is about. So again, it's a rather important document, and it's worth spending the time doing it. So what does it set out? Well, I'll go through it quickly as possible, and we'll go on to the tricks and the other things. It sets out what the issues are. Let's say it's important to the tribunal, whether parties need amendments to these submissions. Again, opportunity to quickly reflect. Do you need to amend your case? Get it out the way sooner rather than later, rather than 2 weeks before the trial or hearing. Will a preliminary issue be appropriate? And as we discussed earlier, there's mixed views on how useful preliminary issues are, but think about it. This is your opportunity to tell the other side, tell the tribunal that preliminary issue might be the deciding thing here. Set it out, think about it. Disclosure, we discussed that exciting topic a moment ago. And there is a tendency amongst people filling out the forms to just say standard disclosure still to be done. And as we discussed a moment ago, it's not necessarily the right approach. You should be perhaps doing a lot more disclosure earlier rather than later. And really, maybe you should be thinking about actually specific disclosure topics and setting out what you think should be disclosed at that stage. Oops. I'm 5 minutes up. Do you want to shut up? Okay, well, it's fine. I was just keeping to the rules. I'll just highlight, sorry, a couple of other things. The questionnaire does set out at the back, towards the end of it, should I say, issues of costs. And you're supposed to set out the costs you've incurred so far. That can come as a shock to some people, as they suddenly discover the opponent has run up £1 million, having done not a great deal. Future costs need to be set out, and also proper breakdowns of costs. Now, it's not a Precedent H court form, thank goodness, but I would still expect you to set down some detail. And you do see huge disparities between parties as to what they set out in terms of their cost information. I have to say, sometimes I'll be very tempted to throw it back at the party if they haven't given proper information, because it's actually rather important. Who signs? Well, it's not like the court. It's any authorised officer of the company or the parties. So you don't go through that process. Now, I was going to very quickly just mention the solicitor versus arbitrator perspective. I was a solicitor. I'm no longer a solicitor. As a solicitor, you do view it quite differently to as an arbitrator. You are reading these documents. You're reading the other side's take on what the actual case is about, probably for the first time. You've seen the submissions, but you have no idea what they really think about it. Also, don't forget, tactics do come into this. Some parties, if you're a respondent, may want to slow things down. You'll find that their timetable will reflect they don't want to get on with it. And people can put very long timetables in an attempt to try and avoid the inevitable. There can be scare tactics used, oppressive behavior used, where you try and frighten the other side by how complicated the case is, how big the costs are going to be. It does happen. Does it open and shut the door to settlement? Sometimes there's a realization that you're not actually arguing a great deal about a great deal here. The cost is going to be £500,000. What the hell are you spending your time doing? There's often a bit of a dance around about mediation as well. It's not like the court. The court, if you wrote, right, I don't want to mediate, will get you a pretty nasty slap across the chops in costs. Arbitration is not quite like that. So you don't need to dance around the mediation question quite so much. Don't forget the cost trap. There is a cost trap. You filled out your cost information in terms of what your costs are. The tribunal can have reference to that later on. From the arbitrator's perspective, I was going to say, it's really, when I'm looking at this, I'm trying to balance out fairness, opportunity for the parties to put their case. So I'm looking at that. I'm also just watching out for parties who are trying to set traps later on by delaying things or looking at to try and produce evidence at the last minute. I don't want that. I want to set it out fairly so everyone has the opportunity to put their case properly. And the one thing I haven't mentioned, and the reason I mentioned this, is there is a question that says, do you think cost capping is appropriate? I have to say, as a solicitor, I used to fill this in religiously. If I was a respondent with a hopeless case, I'd say, yes, definitely cost capping. And if I was a claimant, strangely enough, I wasn't very keen on it. I've very rarely seen this particular point taken up by parties. I have to say, as a solicitor, when I used to fill it in, I very rarely got an arbitrator to make a decision on it either. But it is something that may be relevant in some cases, because you do see costs can run away, and tribunals may want to think about using that power very thoughtfully at times. I'll say no more than that.
Thank you, Gerard. That's very good. You might take the questionnaire as a chore, really, but it is useful. It is very useful. Now, any questions on the questionnaire?
Sorry, can you go through this?
Thank you. My question relates to who signs the LMAA questionnaire. In the case of a subrogated claim, where the claim has been brought in the name of the insured, who has probably long forgotten about his claim, is it possible for the insurer then to sign the LMAA questionnaire, or even though they may not be named as the claimant in proceedings?
Got a bit of a tricky situation there. It's not like the court. The court has quite strict rules about who signs and who's carried out the search. It's not that sort of process. I mean, please correct me, other people on the panel, if you think otherwise. I mean, I think it doesn't necessarily have to be the claimant if he can't find this, this subjective claim, but there has to be somebody who knows something about the case, I think. And I always took the view as a solicitor that the reason I assumed that the signature requirement was there was really to make sure that the client had actually seen this document, and the solicitors weren't running away with the case without telling their clients all the information, particularly the costs information. But that's my own personal take. I'm not sure if that's necessarily correct. But I think the answer is, to your question, as long as they've got some knowledge about the case, that's the most important criteria. They should be authorised to do it, obviously.
Hello, I'm Julia from Reed Smith. I'm a trainee. My question relates to the question in the questionnaire relating to the matters in dispute. I was wondering, to what extent do we have to set out every issue which is contended by the respondent? Should we only list the general main issues in dispute, or should we list every single issue which is contended by the respondents?
I personally take the view that I don't want a huge long list of every single conceivable point, because it'll take a very large piece of paper, or electronic piece of paper, as it were. I think it's really the main issues I'm interested in. Is it a demurrage dispute? Are there particular issues within the dispute? If it's a demurrage dispute, for example, you want to highlight particular issues to be decided. It's to guide the tribunal what the case is about. Think about it, but not everything, is my personal view.
Thank you.
Gerard, when one looks at the statistics that come out every year for the number of arbitrations that have been on documents alone versus the number which have gone to a full hearing, it's always quite astonishing how few actually go to a full hearing, how many are on documents alone. And my question is, do you think the right number of matters are being dealt with on documents alone, or do you think more should actually be going to hearings?
This is asking as counsel, is it? No, you're quite right. It is quite pronounced. What you got to remember, there is a slight nuance on that statistic. It is the number of hearings that lead to an award. Of course, you could have a hearing which doesn't get there. They can settle during the course of it. But yes, there are relatively few. But as I said, the reason I mentioned at the beginning is really for the parties as much to take control of this process. And often you find that the parties are quite keen to have it dealt with on documents alone, sometimes in quite substantial sums. Whether it would be better, I sometimes wonder if it would be better to have a short oral hearing rather than 75,000 pages of submissions which repeat the same point over and over again. If you ask the people who are paying, the clubs and the owners and charters, for example, hearings can be quite expensive, but the point you're making is actually 75 rounds of submissions are quite expensive as well. I think we're really much in the control of the parties on this. If they want to go documents alone, well, I can't force them to go into an oral hearing if they don't want to. And don't underestimate. A lot of the arbitrations are not necessarily run by London lawyers. They're run from China, from Indonesia, throughout the world. Literally, we get appointed by parties throughout the world, and they have no real interest in coming to London unless it's really necessary. So documents do serve very well what they want to achieve. Whether this is the right result, I'd hope so. Yes.
Can I just pick up? I agree with everything Gerard says. I think that's absolutely right. There are some cases where, although I wouldn't try to browbeat a party into having a hearing, where I actually encourage them to think about it. Because, for example, if there's a difficult point of construction on a contract, it's actually quite useful to sit in the room with counsel or solicitors or whoever is representing the parties, and ask them questions and discuss the issue. The alternative to that, if you're doing it on documents alone, is to draft questions that you put to both parties, and that can be quite costly and time consuming. So there's no general position, but I take your point, Richard. There are cases where I think actually it's quite useful to have a short hearing, and it needn't necessarily be expensive. Can I just make a couple of other very brief points about, Gerard's covered it brilliantly, but just a couple of other very brief points about the questionnaire. First of all, I've as I'm sure many of us have, I've sat on institutional arbitrations as well, where the first stage of the process is that you spend weeks or even months drafting terms of reference, which get circulated around to the parties and signed before you even get to the point of any sort of submissions going in. And I think the questionnaire is hugely preferable to that. I think it's much better to get through the submissions and then, as Gerard says, for the parties to focus on what issues have emerged from the submissions and how to go forward with it. The other thing is that we consult a lot with our supporting members, many of whom are users. And I do get asked from time to time, do arbitrators really look at the questionnaires? And the answer emphatically is yes. Now, I can't speak for every LMAA arbitrator or everybody who arbitrates on LMAA terms, but what I can tell you is, in my experience, we look at them very carefully and find them enormously useful. So please don't be discouraged. If they seem a bit of a chore, it really is worth it because we do take a lot of notice of them.
Thanks. Anybody else on this topic? We covered it, I think, have we? No?
One question.
A question on the back. Okay.
Thank you. I should say Kevin Cooper, MFB. Just following up on Gerard's point, which is that parties overseas might not be interested in coming to London, that sort of triggered a thought, well, would they need to these days? Because, of course, the English court certainly has moved very willingly, I think, towards remote hearings. Most of the Admiralty stuff that I've done recently has been remote hearings, and some of the Lloyd's Open Forum stuff has as well. Just out of curiosity, because I don't have a feeling for this, how much have oral hearings in LMAA proceedings moved towards virtual hearings?
Can I take that one?
Yeah.
Hard to generalize, Kevin, because we don't keep any statistics of that. We don't inquire of all the arbitrators who are sitting on LMAA terms and procedures. What I can say is that we are very accustomed to dealing with hybrid and virtual hearings. And in fact, way before COVID, we were accustomed, as you know, to receiving witness evidence and expert evidence remotely and so on. And in fact, we were one of the first arbitration institutions to develop what you might call a code of conduct, which now form one of the schedules to the LMAA terms. So the answer is that we encourage it and we're very keen to do it. I can't give you any statistics, but it does happen. And certainly if it's a way of saving cost, we would entirely support it. I mean, you hear all sorts of arguments, don't you, about the pros and cons of virtual hearings. Some people say, well, I can cross-examine a witness better if they're in the room, and it's better for us all to be there in person. But there's always a trade-off against cost and convenience and expedition and so on. But I think the short answer is in the right case, yes, we positively encourage it.
Right. Now, the next subject is, what do arbitrators find helpful or unhelpful? How to improve submissions. Now, this topic is not allocated to anybody. Any of the 5 here or 6 can put their views. May I start? I'm very hot about that, actually. I'll let you speak about other topics. Please not be aggressive in your exchanges, and do not attack your opponent in person. Just stick to the issues. And I think aggression had gone away, but it's coming back. I see a lot of this going on. You don't win points with arbitrators, particularly when you use abusive language in a sort of aggressive tone. So please be civil and kind to your opponent and stick to the issues. So
Yes, I think focus on the issues is what we're really interested in. We're not interested in point scoring and so on. But the other plea I would make is I increasingly find cases where I'm being asked to act. The LMAA terms, as you know, provide for claim submissions, defence and counterclaim if there is a counterclaim, and then a reply and defence to counterclaim, and potentially one further reply in relation to the counterclaim. I'm increasingly finding cases where parties are sending me rejoinders and sur-rejoinders. And one of the things I find that concerns me about that is that they're very often just repetitive. They're not genuine rejoinders. They're not addressing new points that have been raised. So my plea is, please don't be repetitive. We get the point when it's made once. It doesn't acquire additional strength by repetition.
Try to keep things as short and concise as you can, and particularly in interlocutory stuff about extensions or applications for preliminary issue or disclosure. Do not go over the next page if you can, please. And if there's an extension, if you're going to agree the extension, just agree it and say, well, we won't take, we don't take issue with what they've said. What's really irritating is when people sort of agree the extension, but then go on and on about how they sort of take offense with what's been said. And it's much better to just draw a line and say, we're rising above it. If you can, don't go low. That I really agree with Aleka. It does your client no good. It does you as a professional no good. And don't do it.
You do feel better when you've done it sometimes.
Well,
Send
don't press
yourself.
send. Don't press send.
Press delete.
Yeah. Yeah, I don't have a mic now, but yeah, obviously I agree with what David and Clare have said, and I would just say, we're people too. You want us to make a decision on something. Tell us what it is that you want us to do. Explain how and why. Preferably on one page. And even if your opponent has spent 10 pages on the same point, can you condense it and sort of throw everything up on the wall and see what sticks, and we've got to sort through it all, is quite well, we don't find it helpful, and we don't enjoy doing it. It's much better to be concise. What is it you're looking for? What do the other side say? That's it.
Gerard?
I'd say the two little things that niggle me are that I don't always get told when I've pointed to who the other arbitrator is at any time. So it's the point that submission will be served. Quite helpful to know on the occasion. It would also be helpful if you did attach a copy of the arbitration report. If we're using arbitration, I trust you. You tell me it's an arbitration. But it would be helpful if you just sent me a copy. And the reason I say that is because I do read them carefully, and I did find somebody tried to point me as sole, and I went, hang on a second, you can't do it under this provision. So I'll probably save their bacon and probably save a lot of money because we could have gone a long way down the line before realizing I hadn't been appointed properly. So those are two little niggles, and really I say keep it short. Try and agree things if you can agree things, because if you write to an arbitrator and say, could you decide this about a time extension of 15 minutes or 13 days or whatever it is, I have to spend time reading it. I don't mind doing that, but I will charge you for it. You're not doing your clients any favors. If you can agree 14 days, just agree 14 days. But don't write on the first time extension application, I'll give it on final peremptory terms, because I'm not going to give it to you. You're wasting your time and you look a bit stupid, really. There may be times and occasions where it's appropriate to write that, but not on the first time. And don't write to me saying I want indemnity costs every time, because it's highly unlikely I'll award you indemnity costs at that moment in time, unless it really is truly necessary. But it's quite a high legal threshold for awarding indemnity costs, and it doesn't necessarily mean what you think it is. Those are the things I was going to mention.
Can I just mention very briefly one very personal concern that I have, and I don't know if everybody shares this, but this may not be popular among some of you with the law firms, But if counsel has been involved in drafting submissions, then I do like to see counsel's name on the submissions. And actually, it's not because it will influence my judgment on how I view those submissions. There's actually a very good practical reason, which is that when you look at conflict issues, and if you were to look at the IBA guidelines on conflict, there are circumstances in which the identity of the counsel is significant to us. And I won't go into any details, but I have been caught out on a case where I wasn't aware that a particular counsel was involved. Now, you might say, well, if I didn't know, then it couldn't have affected my judgment. But the problem is that if it comes to light halfway through the reference, you then get into an argument about what you knew or ought to have known or might have known. So my preference is if, and I recognize that sometimes it's said that if the law firm's been involved in redrafting, then it isn't counsel's draft any longer and so on. But if counsel's been involved, I like to know. Please.
I mean, I think that is practice. It's recommended practice, and there can be criticism if you don't do it. I understand that is part of the guidelines, and I think it's fair to recognise where the works come from, and I don't think there's a downside.
No.
Putting both names is actually very common, and
Yes.
I think that's quite a good compromise.
Francesca, you have some questions?
Yes, I have. So what arbitrators find helpful or unhelpful as regards to oral submissions at hearings, especially if held remotely, virtual hearing?
I mean, in a sense, much the same as we've said in relation to written submissions, I think. Personally, I find remote hearings quite good. I find you can see people, you can keep a close eye on what's going on. I'm not sure there are any fundamental differences in what I expect or find useful, but Sara may have a different view.
Yeah, I have one that I've experienced that online is that people don't know when to stop. And it's very difficult to, you don't want to interrupt, you don't want to stop them, but there is, non-verbal cues when you're in a hearing or hearing room, I don't know, that message is easier conveyed. And it's particularly relevant, I find, when you have the representatives arguing may not be from English firms or trained in English maritime law. And you can have rules about like stop clocks and sort of chess, as they call it, that you each have sort of so many minutes. And I found that for difficult online hearings like that, particularly also interlocutory, I think, I've got my chance to, explain why it's really important. And it's very difficult. You can spend hours on one small point. And so it's quite important to have those rules of engagement beforehand.
Yes. What arbitrators find helpful or unhelpful as regards to structure and organization of hearing bundles?
Oops. Make sure that the page numbering of the bundle is the same as the PDF.
Yeah.
That's important.
And PDF bundles indexes with links to the actual document. And a personal plea in terms of, I think it's in the guidelines not to repeat emails, not to have, every single email in the stream, etc. But also in terms of experts' reports, for example, quite often attach documents that are referred to elsewhere. And particularly in terms of sampling, very long explanations, etc. It can be, you're sort of looking at it and think, but I've seen that somewhere else, haven't I? Where is it? And then you spend an awful lot of time trying to assess, is it something new or is it not new? So it should only be in one place. And if you do, you are allowed to take it out from the experts' reports and say they're all in, just make a reference to where they are. Or if they're not in the main bundle, that's because they're in the experts' reports. It's just a matter of case management that we're not wondering, having to cross-check that are we reading the same document or another document that's different, just looks very similar.
It's all in the in Schedule 4, actually. The problem arises not with English lawyers so much, but with those foreign lawyers. But if you read all this, there's a very good outline how to present the bundles in Schedule 4, isn't it? Yeah.
And just before Bruce comes in, can I just say in one sentence, large shipbuilding disputes, offshore construction disputes, a core bundle, please. And the core bundle can evolve during the course of the hearing, but it's enormously helpful. And I like everything electronically. Not everybody does. Sorry, Bruce.
Not at all. I just thought it would be helpful to remind everyone that there is quite a useful checklist at the back of the LMAA terms as to what we would like when it comes to preparing for hearings. And that covers most of the points I think that have been raised. Just generally, I think that I agree, though, in terms of all that's been said, we want logic, simplicity, economy of terms. And I remember many times in one recent case, a particular senior solicitor in London would start every interlocutory letter with, "We can be brief." And each of those letters was at least 3 pages long, quite unnecessarily. Anyway, otherwise I agree with everything that's been said. Thank you.
Now, the next topic is on becoming an arbitrator. Who would like to become an arbitrator?
I'm hoping everybody here would at some stage in their career. This is, I hope you'll forgive me for taking 5 or 10 minutes of your refreshment time, but this is really, really important to us. And it's one of the main reasons why we're all here this evening, is to spread the word. And this is directed not only at people who are thinking about becoming arbitrators immediately, but those of you who might consider it later in your careers and maybe undecided as yet. I'm going to take this briefly because there's one very big takeaway. The first thing is that there is now guidance on the LMAA website. So please have a look at that. There's a page on there on how to become a maritime arbitrator. But the big takeaway, thank you, I drafted that. I'm glad it's good. But the big takeaway is this, that if you're interested, please talk to me. Over the last few months, I've had one-to-one conversations with well over 30 people from a diverse range of backgrounds, either in person or on Zoom. I intend to continue to do that when my term as president comes to an end in May. Gerard and I have given talks to, among others, a group of Erasmus students and a Turkish dispute resolution club. Ben Goss, one of our recent full members, who's a former broker, has spoken to a group of trainee brokers from Germany. And we've also delivered a similar message to the delegates on the Chartered Institute's virtual diploma course in international maritime arbitration. So please, if you're interested, don't hesitate. Send me an email. And if I can't get back to you immediately, I'll get back to you at some stage. And it occurred to me that in the Young Maritime Professionals group, if there's enough interest, then rather than do it one-to-one, we might have a little group session with some coffee and half a dozen people there and a question and answer session, which I'd be absolutely delighted to host. Very briefly then, against that background, because that's the main message, but very briefly, how do you become a maritime arbitrator? Well, I'm going to start by talking about people who are not at the bar. And I think the starting point is raising profile among users in the early stages of developing your practice as an arbitrator. I'm afraid you're very much on your own. You've got to get out there and talk to as many people as possible, make them aware that you are interested in arbitrating and tell them why they should appoint you rather than someone else. In other words,
you can't do that.
Let me rephrase that. Let me rephrase that. Let me rephrase that. There are, you're quite right to pull that up. There is guidance on ethics on the LMAA's website about the way in which this sort of thing is done. What I meant by that shorthand was what qualifications and experience you have that suit you to being an arbitrator for the sort of disputes that users might have. I'm not suggesting for a moment you should say, don't appoint this bloke Steward or anything of that sort. It's not a comparative thing with other arbitrators. It's a question of why you would be well suited to arbitrating. So look for speaking opportunities at conferences and seminars. I use LinkedIn a lot. I find it a very convenient way to publish comment and articles. The old days of having to get into the print press through Lloyd's List or something are long gone. We can reach our target audience by writing on LinkedIn. And I encourage you to speak to the full members of the LMAA who've become full members recently, because they'll be able to tell you what they did. In the early stages, there's a limit to what the association can do to help. There's very limited scope for us making appointments. As I mentioned earlier, we don't do that. But there are benefits to supporting membership. Supporting membership for £120 a year gets you into the arbitration community. For those of you who aren't already supporting members, gets you invited to events, opportunities to meet users and other arbitrators, an opportunity to receive and write for our monthly bulletin, which helps to get your name out there. So that's a very brief overview. And Claire, are you going to say something about barristers?
Before you go, Claire, can I add, and this is a very important comment, well done. You've done very well. Somebody on the website, but in my view, whatever you do, all the publicities and the networks and all that you're using, is all down to trust. People who appoint you trust you, not because you're going to give a good decision to them, but you have to inspire people that you know what you're talking about. But it's not just how many people you know. Okay, bear that in mind.
This is good.
Yes, well, I was briefly going to talk, having come from the bar, I can certainly say that sitting as an arbitrator is really interesting, very enjoyable. It's a really useful way of learning to become a better practitioner, whether you're a lawyer or in commercial end of things, even if you don't want to do it full time. I know that people ask questions as to how you become an arbitrator and what you need to do. I think it's useful to understand, in a sense, why there aren't any young maritime professionals as full members of the LMAA. There are some quite stiff barriers for full membership. One of them is that you can't be a full member if you are a practicing lawyer or if you're full-time in a commercial entity. So that does, in a sense, can be a barrier for many. The other aspect is, on the application form, you do need evidence of sitting and give the numbers of LMAA cases you've done, how many cases you've done with full members, and have you sat in an oral hearing. And so ultimately you do need to clock that up to get a good chance, as things stand, of becoming a full member. Now, I think there is room for debate as to whether those barriers are the right criteria for getting a strong and diverse membership with people like you as full-time arbitrators. But that's a debate perhaps we can have over a drink. Fortunately, if you want to arbitrate, you don't have to depend on getting through those thresholds. As a supporting member, there are no restrictions on appointments you take, and we see at bar a huge number of people doing a lot of arbitration as supporting members. And as a supporting member, you essentially join, you get seconded by I think, whether it's a full member and a supporting member, or it's an easy pathway to enter. And I would strongly recommend it if you want to do arbitrate, because in terms of any criteria for requiring a member, you only need to be a supporting member. You don't need to be a full member. So if you're interested, speak to your clerk, speak to your principal. If you're employed, you probably need to try and work out a way of getting time to do the arbitration within your job. But I think most people want to encourage new faces. It is a good thing. And I think anybody who is a principal here should be encouraging that. Tell people you want to take on appointments. Somebody like Francesca, are you taking on appointments? Let people know, because I think we do want new faces, and that's the way to start getting appointments. I think David's right about attending conferences and going to LMAA events. As a supporting member, you can tell the LMAA you're willing to take appointments, and that's a good way of showing you're available. The Chartered Institute does courses. You can become a fellow. It's easier if you're a lawyer, but you don't need to be a lawyer to do that. It does take some time and some money, but it does give you some grounding in writing an award, and it shows commitment, and in a sense it raises your profile. You can put on LinkedIn, I'm now a fellow of the Chartered Institute. I don't think it makes much difference, but if you're trying to do things on your CV, it's certainly not a bad thing. It's more getting out there and talk to people who are sitting and say, well, I'm really interested, and try and pick up those appointments, because as I say, that is the way to get to the full-time arbitrator.
Okay, well, those who are non-lawyers, actually, perhaps they should do the CR course, the domestic arbitration, which is very good. It teaches you the basics of English law first, and then the second part is the writing of awards. Those who are not lawyers, those who are lawyers, you don't need to do that, other than learn how to write awards later on. It's a matter of practice, or take the course, second part. What our stage manager has to say.
You just answered the question that I had. So
Do you have any question yourself?
is anything else that youngsters should do if they think about applying to become an arbitrator? Like, apart from, of course, taking courses, attending events, but like, let's say you are an in-house lawyer, for instance, what would you do? Is there anything you want to try and do to strengthen your CV ahead, or you can think of?
Sara was an in-house lawyer.
Yeah,
She'll be able to answer.
Spent most of my time in-house, actually. Yeah, I didn't think about becoming an arbitrator until I stopped being an in-house lawyer. So I approached it the wrong way around. But having learned from that experience, I would say it's actually a very good training ground being in-house, because you have to deal with all kinds of situations, cross-border situations, all kinds of disputes in all kinds of fields, not just charter party disputes. So that's very good training ground. But I would also say the advice that was given to me is exactly what David and Clare and Aleka have said. But the main component, or the most important thing, is if you decide you want to do it, talk to other people, talk to the arbitrators here this evening to say you want to do it. And you have to say it out loud. You can't just put yourself on a list. You can apply to be a supporting member. You can get the support to do that. Put yourself on the list of supporting members willing to accept appointments that, frankly, is quite difficult to hide. That's a different issue to be addressed, but sorry, it's difficult to find. And that was the main barrier when I started and was going around to see people and saying, look, this is what I'm interested in doing. I'm starting to do it. I had a business card and I had a website, and that was advice that I was given to do so that people could find me, basically. And even though I was on the list of supporting members accepting appointments, people still had trouble doing that. And also, if you put yourself on the list, it's a very passive way of doing it. It's not just appointments aren't just going to roll in unless you tell people. It's a bit like changing job or anything. It's like you have to say it out loud and you have to act on it.
Bruce, final word.
Me again, I'm afraid, but a little bit of personal history, which some of the younger people might find encouraging. It had never occurred to me to take up arbitration at all. But I was approached by one or two people when I joined Thomas Miller many years ago, who suggested perhaps I would like to be an arbitrator, or at least do some arbitration. And so I told those who I knew who had the gift of appointment that I would be interested. And to my astonishment, some people appointed me. Astonishment in particular, because at that time I was only 30 years old. And in those days, and that's a long time ago, I have to say, in those days, there was a traditional view that you could not become an arbitrator until you were at least 40. And I was only 30. And 5 years later, I gave up my job for Thomas Miller and started arbitrating full time. So there is hope, but you have to put yourself out there, as you say.
Thank you very much. Wasn't that a very useful interactive play, wasn't it? I did enjoy it, did you? Well, our arbitration events are very, very popular and in demand. The next arbitration event we have, Gerard tells me, is on 14th of March. Yes, and it's quite a very dynamic panel and very juicy subjects. Oh, well, I take for granted. After you is the second, you see, a dynamic panel again. And on 10th of April is a less dynamic panel. No, it's a very, I don't remember the title, but we have another 2 arbitration events coming. And tell us if you want this type of events again. Please tell us what you like to have. Interactive play is the most attractive way to learn together. And I tell you, I never did a monologue lecture when I was teaching at UCL. The most enjoyable lectures, I had a good name for that actually. I was interacting with my students. Now, enjoy the drinks, which are, and nibbles, very generously sponsored by the LMAA.